Representative Peterson.
Thank you, Mr. Chair. I would move second substitute, House Bill 298 in my name.
That motion is in order. You wish to speak to it?
I do. I appreciate the sponsor and his good efforts in making and drafting this policy. I support the policy move. What this substitute does is it basically strikes Section 102 out of the first substitute, which is the findings and purpose section. The reason for doing that is that our code typically instructs the executive branch on how to do their duties, what the rules are of the game. And Section 102 of the first substitute really is more of an airing of grievances and explaining what the problem is that we're trying to solve with this draft. That kind of language, in my view, is more appropriate for a resolution rather than being found in the code itself. And my fear is that this would set a precedent where all of us would want to start providing preambles, so to speak, in our bills, and that's kind of a change of how we've done business in the past with drafting our bills. I mean, I've got a lot of amendments I can make on the floor with new language explaining why I'm running a bill. So I think that this findings and purpose section, if we would like to do that as a legislative body, we should get together with leadership in the House and Senate and determine if that's how we want to draft our bills moving forward. But in this case, I just think it's inappropriate. And I would support the sponsor if he wanted to open a bill file on the House floor and put this language in. I think that's fine. But I just don't think it's appropriate for this bill. Okay,
Representative Peterson, point of order. You need to delete entitle and body in your motion.
Oh, yeah. I moved to delete entitle and body. First substitute House Bill 298, or we've adopted the first sub? Is that correct?
We have.
Okay, I missed that. Sorry. Delete entitle and body. First substitute House Bill 298 and replace with second substitute House Bill 298.
Okay, that's in order. Go to the original bill sponsor.
Thank you. While I understand Representative Peterson's substitute, I would state this, that I'd oppose the amendment for these reasons. This language is clearly stated in the Federal Lawful Commerce and Arms Act, not to say that we should echo or follow the lead of our federal legislators, but this language is echoed in there or from that section of federal law. The language clarifies the intent and the important context to the bill. And let me give you a couple of examples. By deleting lines 50 through 54, they read, businesses in the United States that are engaged in interstate and foreign commerce through the lawful design, manufacture, marketing, distribution, importation, or sale to the public of firearms or ammunition products that have been shipped or transported are not and should not be liable for the harm caused by those who criminally or unlawfully misuse firearm products or ammunition products that function as designed and intended. Another section, 76, lines 76 through 79, excuse me, limit causes of action against manufacturers, distributors, sellers, and importers of firearms or ammunition products and their trade associations for the harm solely caused by the criminal or unlawful misuse of firearm products or ammunition products by others when the product functioned as designed and intended. I think this intent language it needs clarification to Representative Tanner's questions. These are obvious questions that come up when we talk about a bill like this and a change or a perceived immunity, which this is not. Protecting our Second Amendment right is more than a resolution, or I feel it's more than resolution language. It's a constitutionally protected right for us, not just a matter of policy, but an inalienable right. And I would also state that other states, like I mentioned earlier, have adopted resolutions and also passed legislation in rejecting any federal act of Congress or executive order limiting our Second Amendment rights. This language in this bill, I feel, is far less vitriolic. And then my final question would be, do we disagree with the findings and purpose, do we disagree with the Second Amendment to the United States Constitution providing that right of the people to bear arms, keep and bear arms, shall not be infringed? For those reasons, I would oppose the amendment.
Representative Roberts, to the
Substitute.
amended bill.
Yeah, to the motion, comment. Yeah, I think this is an interesting discussion, not necessarily entirely related to the legislation here, but maybe process and how we draft things and do things, and what the practice has been as far as drafting. Maybe I don't know if this is appropriate or not, but asking a question and pointing out the other ways that I've seen this is done. Can't we read and have intent language added after we have a bill approved on the House floor, and it's.
So if you're
I
making
haven't been here as long as some of you guys. So.
If you're making a citation, if it's okay, Chair, if I answer, if you're making a citation and reading something on the House floor, typically they will spread that on the journals or spread that on the pages of the House Journal. There's ways for things that are not statute to be read into the official record of the body for the session. But typically, when there's been an expression of legislative will, or if you want to call it legislative complaining, that's been done in a resolution type format historically.
Mr. Chair, may I respond to that question also?
Yes.
It's my understanding that the courts, and some of you may know better than I do, but the courts, when looking at intent language, and if they reference a discussion on the floor, for example, or committee discussion where intent is specified, they're just as likely to look at intent language in the bill that would be found in this, or just as unlikely, I guess, in this case, to look at the section of findings and purpose.
Representative Ray.
Thank you, Mr. Chair. As parliamentarian, intent language, once you pass the bill, if you have prepared intent language, the speaker comes back to you, and you can say the legislature proposes the following intent language, and that's voted on. And then that intent language follows with the bill. So we're to go to court, you've got your bill, but then you have the intent language that we actually voted on and passed immediately after the bill. So that's how you would add your intent language if you wanted to do that.
Thank you.
Would that be more appropriate?
Yeah.
Representative McKiff.
Thank you, Mr. Chairman. I agree with the motion made and the comment made by Representative Ray. I think those are both accurate, and for that reason, I would support the motion to substitute.
That's fine.
Okay. Seeing no further comments, I'm going to place the motion. You, Representative Peterson, you wish to sum?
No, I'll waive.
I'm going to place the motion of voice vote. Okay.
Representative Brad Daw. Representative Kay McKiff. Representative Ed Red. Representative Steve Elison. Representative Jeremy Peterson.
Yes.
Representative Angela Romero. Representative Sandra Hollins.
Yes.
Representative Paul Ray.
Yes.
Representative Earl Tanner.
Yes.
Representative Mark Roberts.
Yes.
Representative Don Ibsen.
Yes.
Unanimous.
Okay, the bill is amended. We have a second substitute before us. That voting was unanimous.